Hi, I'm Dustin Saldarriaga, an immigration lawyer with Scott Legal PC in New York City. One of the most common questions around the EB-5 green card is, when can I get my money back? It's a good question and a timely one, since USCIS gave us new guidance on this exact question just a few days ago in early October of 2023. In this video, we'll walk you through what that guidance says and get to the bottom of how long your EB-5 investment needs to be maintained and at risk in order for you to qualify for an EB-5 visa. Before we get started, please take a moment to hit the like and subscribe buttons so that you'll be the first to know about the most up-to-date options to visit, work, or live in the United States. So, the EB-5 green card. To quickly recap, the EB-5 is an immigrant visa that gives you permanent residence in the United States, or a green card, if you invest $1,050,000 into a business in the United States. The investment amount is reduced to $800,000 if the business is located in a rural or high unemployment area, also called a targeted employment area, or TEA. After this amount is invested, it must be put at risk and made available to the business so that it can create at least 10 permanent jobs for US workers. Those are the basic investment and employment requirements for the EB-5 green card. If you're interested in learning more about these requirements, we've linked below to our videos that go into them in much more detail. As we talk about the investment time frame, we'll be referring to the EB-5 application process. So let's do a quick overview of what that looks like. Step 1, if you're applying for an EB-5 green card, is to file the form I-526 with U.S. Citizenship and Immigration Services, or USCIS. Once the I-526 is approved, which is currently estimated by USCIS to take around 5 years, you can apply for a conditional green card. This is done by filing the form I-485 if you're inside the U.S., or by filing the online form DS-260 with a consulate if you're outside the U.S., or if you just prefer to apply at a consulate. Once that's approved, you get conditional lawful permanent resident status, which is valid for 2 years. Why conditional? Because at the end of that 2-year period, you must submit a form I-829, which gives USCIS a chance to look at the EB-5 application again and decide whether in the longer term you've actually invested the required funds, created the necessary jobs, and otherwise continue to qualify for the EB-5 green card. Keep in mind that since the I-526 is taking about 5 years, it could be 7 years or more before you're able to file the I-829 application to remove the conditions from your green card. Once USCIS approves the I-829, you get full unconditional lawful permanent resident status, a full-fledged green card. So at what point in this process can you get back your $1,050,000 investment or your $800,000 TEA investment? The answer depends on when you filed your EB-5 application. Specifically, whether you filed your I-526 form before or after March 15th, 2022. March 15th, 2022 is the date that the EB-5 Reform and Integrity Act, or RIA, went into effect and changed a number of laws related to the EB-5 program, including the law that says how long your funds need to remain invested. So in this video, let's look at how long the investment needs to be sustained if you applied before March 15th, 2022, we'll call these applicants pre-RIA applicants, and how long it needs to be sustained if you applied on or after March 15th, 2022. We'll call these applicants post-RIA applicants. If you filed your form I-526 before March 15th, 2022, you need to maintain your investment through the entire 2-year conditional residence period. That 2-year conditional residence period starts on the date that your adjustment to conditional permanent resident status became effective if you applied by filing an I-485, or on the date that you entered the United States if you applied by filing a DS-260 at a consulate and received an immigrant visa. This unfortunately means that if it takes USCIS 5 years to approve your I-526 petition, which again must happen before your 2-year conditional residence period can start, you could be looking at a total of 7 years or longer that you need to keep your funds invested in the EB-5 enterprise. If you don't keep your funds invested this entire period, USCIS may decide that you are not eligible to have the conditions on your permanent resident status removed, which of course is an outcome you want to avoid. This means that if you're a pre-RIA applicant who invested in a project that's scheduled to return your funds before your 2-year conditional residency period is complete, you may need to redeploy your investment capital to meet the requirement. But what about the post-RIA applicants, those who filed their I-526 on or after March 15th, 2022? They get a better deal since they only need to sustain their investment for 2 years. USCIS has said that the 2-year period starts on the date when the full amount of the investment, again $1,050,000 or $800,000 for a TEA, is made into the EB-5 business and the business has full access to it in order to create the 10 required jobs. That's the general rule for applicants who apply on or after March 15th, 2022, but there are a few scenarios that are worth looking at. The first is when the investment is made more than 2 years before the I-526 form is filed. Do you need to sustain the investment for more than 2 years in order for it to remain at risk when the I-526 is filed? According to USCIS, the answer is yes. If you made the investment more than 2 years before the I-526 is filed, you should continue to maintain the investment at the time the I-526 is filed. Here's another scenario that's unfortunately very likely to occur given the very long delays impacting the I-526 form. What if someone applied on or after March 15th, 2022, maintained their investment for 2 years, but USCIS has not yet issued a decision on their I-526 petition when that 2-year time frame is up? Can the applicant take back their investment once the 2-year period is met, even if the I-526 is not decided? In a response that isn't exactly reassuring, USCIS says, likely yes. In other words, USCIS would likely not deny the application of someone who meets the 2-year requirement, but takes back the funds before the I-526 is decided. But if you want to sleep better at night, it's probably best to just maintain your investment for at least 2 years and until you get a decision on the I-526, even if that means that your funds are invested for longer than 2 years. There's one final topic that's important to cover in this video, and that's how this requirement to maintain the investment interacts with the employment requirement, meaning the requirement that the investment create 10 jobs. For example, how does the timing of when those jobs are created affect how long the investment needs to be maintained? The answer is that the investment must be maintained until the EB-5 business has created the required 10 jobs. This is the case even if it means that the investment must be maintained for longer than the 2-year period that applies to post-RIA applicants. In other words, don't take back your investment before you've created the required jobs. And what if the post-RIA applicant creates the 10 full-time permanent jobs before the 2-year period that they need to maintain their investment? Unfortunately, meeting the employment requirement won't free them from the requirement that they maintain their investment for the required 2-year period. For pre-RIA applicants, the requirement is a little bit simpler since the investment must be maintained through the end of the 2-year conditional residency period. So someone who applied before March 15th, 2022 would not be eligible to take back their funds earlier, even if the jobs were created before the end of the conditional residency period. We hope this video about the EB-5 visa was helpful. If it was, please click the like and subscribe buttons to stay updated on future videos about visa options and travel to the US. Thank you for watching.